Announcements from Young Lawyers Group.
Thank you for coming, and before you leave, we will have parking validation, so make sure to grab those from me before you head out. Now it's yours.
It's all mine. All right. So, nice to be here. I remember being in a presentation like this, I don't know, 16 years ago. I hate to admit that, but it is what it is. I learned nothing. And it was on estate planning. I learned absolutely nothing. So that's my job today, is to teach you nothing. No, that's not the case. I really hope. In fact, as I was going through this again last night, I kept wondering, what can I share through 16 years of practice that these good people can take away into their own practices. And I truly hope that there's something, if nothing else, as a collective of lawyers, estate planning especially occupies, I think, a very special place. In other words, the camaraderie, I think, is very high in this field. We tend to share. We share resources, ideas. We see each other in CLE events. So, if nothing else, you have my name, my number, my email when I respond, right?
Yes.
When I respond, Christy knows how to find me. But I'm always happy to share ideas with you. I hope to share a lot of those today. And again, I hope this is useful information. All right, so this is going to seem a little abstract. I know that. So when I talk about this whole idea of where to start, a technician or someone that likes to be in front of clients. So in my years of practice, I see estate planning attorneys, not truly in those two camps, but you tend to find personalities that match up well with clients in the conference room, right? You enjoy being in front of people. You enjoy asking questions, getting information. And then there are those who what? Want to work behind the scenes. So if you are going to practice in this area, one of the first things I promise you that will save you a lot of headache is to determine what your personality type is. If you are more of the technician, then you really need to find people who are willing to go out and market in front of you, meet with clients in front of you, or try to grow skills so that you're more comfortable meeting with clients. Now remember, when clients come in to see you for estate planning, what is really driving them to get this done? What thoughts do you have? Is it all the finer details of tax law, or is it something much more basic? It's much more basic. You know, the gentleman I met with my 10 o'clock appointment today, didn't know anything about tax laws. I mean, he knew that there was an estate tax, didn't know what that exemption number was. The most concerning thing to him today, and it has been for a number of years, was the succession of his business in the event of death or incapacity. And then he wanted to make sure that his children would not fight as that business, in this case it was kind of a father and a son. It's not always the case, but as the business passed from him to his son, he wanted to make sure that there was fairness in that estate plan. Beyond that, he was here to find out how to put that puzzle together. All right. Number 2, where will you practice? I didn't ask anyone here, but I imagine there are maybe solo practitioners, folks in small firms, medium firms, large firms. So I did some work at Parr Brown out during law school and when I came out. And at the time, the firm said, estate planning isn't one of those things we necessarily want to pursue. We sort of do it on the side, but Matt, if you're willing to come into our our litigation practice, no way. No way. I'd be a lousy litigator. Horrible. So I decided in my pursuit of estate planning to seek out a couple of attorneys who did this on a regular basis. So when I came out of law school, I really put my shingle out. I mean, truly did. 2 attorneys, and we went everywhere in this state. I mean everywhere. To present estate planning, banks, credit unions, insurance firms, broker-dealers. I mean, we went, again, all over the state. Now, that was fine for me. I was willing to do that. As you sort of land in a solo shop, the biggest concern I suppose you have is being able to practice competently in that shop of yours, right? So one of the most important things, and we'll talk about this in greater detail, is maybe the documents you use. Do you borrow them from another attorney? Do you go out and secure for yourself in that practice BNA, American Academy documents, Wealth Council documents? That will be one of the more critical decisions you make. What documents will you buy and use to support your practice as you go forward? Mentors and partners. I'm supposed to be a mentor in this firm. Usually, and Christy has asked me to sort of bring her along in the estate planning practice. I typically find that I'm following her more than she's following me. But I suppose in a larger firm, that's one of the more important paths you'll follow. The fact is, not every senior partner will want to be that mentor, and that's tough. You know, there are some brilliant men and women in the estate planning area, and what's interesting is sometimes they simply do not want to share. It's not really that they're unwilling, but estate planning is typically conducted by that individual attorney. In other words, I don't really collaborate on a daily basis with 2 or 3 other colleagues. Because most of what I do, whether it's a trust-based plan, whether it's the creation of a limited liability company, whether it's funding the trust, I can do with my own support staff, my assistant and my paralegal. I can really do 90% of it. So sometimes you'll have this mentor that's been in the estate planning practice for 15, 20, 30 years. He or she has 500 clients, 1,000 clients, 1,500 clients. And they're so busy they won't take the time to bring you into that practice. That's not always the case. But what you'll need to do is to really have a heart-to-heart with that partner to find out if he or she will commit the time and the resources to bring you into that practice. That might mean that you have to create ways to get in front of that partner, right? Maybe it's like Christy and I, we try to meet once a week. And where I might be distracted with all sorts of projects, and she might be distracted with the number of projects, what we're trying to do, though, is to carve out time so that I can sort of pluck from my practice projects and issues that she can handle, that she can run with, that she can learn from. So that's a lot different than a litigation practice where a lot of litigation teams are composed of 2, 3, 4, 5 attorneys. You got a big project. Someone is in charge of this deposition and this discovery request and so on and so forth. A lot of estate planning, though, is that one person, that one lawyer. So, documents. I have reviewed thousands and thousands of wills and trusts. I've seen great documents and I've seen horrible, horrible documents. So a couple of pointers. Don't borrow documents that you're not really familiar with. In other words, this practice of law changes frequently enough that the medical directive that you borrowed, the power of attorney that you borrowed, the trust that you took off, the firm's computer system, might be so outdated that the first plan you put together creates that bomb, right? So my advice is, if you are in a well-established firm where the documents are updated on a regular basis, you're probably in great shape. Great shape. If you are the estate planning person in the firm and you are looking now for good forms, go out, invest the money. If you can convince the firm to buy a software program, I think it's money well spent. So as an example, when I came out of law school, I joined a group called the American Academy of Estate Planning Attorneys. Now this is a pretty unique group. There aren't many associations like this. The American Academy of Estate Planning Attorneys was formed by a couple of estate planning guys in California who went out into the community in the 70s and 80s when trust planning was just taking shape and form. And they put together literally thousands and thousands of estate plans. And they went out and said, you know what, we've made a ton of mistakes and we've made some very good decisions. Why not bundle this up, our knowledge, our marketing acumen, our documents? Well, we've created this proprietary software program. Why not invite other attorneys in other states to participate in this and kind of move ahead more quickly in that learning curve than we ever did? So that's what the American Academy does. There's a pretty big buy-in fee, and then there is this monthly fee to have access to that proprietary software, to have access to what we call a practice building consultant, someone who says, hey Matt, I know you're the lawyer, but don't forget about the business of estate planning. Let's check your numbers. Let's check your retention rate. Let's see how much your staff costs. Let's do all this. Now that's, in this bigger firm, that's not as important as it used to be when I was in a two-person shop. But that was an extremely important thing for me fresh out of law school. To be able to kind of walk into a situation and practice more competently sooner than try to cut my teeth over 5 or 10 years in practice, hoping to catch the crumbs from more senior attorneys in my firm. Apart from the American Academy, this is a couple slides ahead, so I'm getting to it a little bit early, you also have Wealth Counsel. WealthCounsel.com emphasizes documents rather than the marketing. So again, in a solo or small shop, Wealth Counsel has terrific documents. And again, what you have is this collective of attorneys all over the country who participate in discussions about estate planning, the challenges, conflicts of interest, how to deal with clients, retention issues. But more importantly, the collective is committed to keeping that software program relevant and current. So if you've got that loaded on your system, you might have update 3.11 that you download on Monday, and that brings in the most current tax provisions as of the last tax act, December 17th of 2010. So again, it allows you to, in some situations, you don't have the luxury, or maybe you're forced to commit a lot of time to become the technician, and then the software engineer, and then the marketing person, and everything else. By bringing these other third parties on board, that allows you to do what? To maybe be in front of that client more. And it's ultimately the client that pays the bills, right? So, a couple of thoughts there. ABA, local associations, again, a great way to learn, a great way to cut your teeth. The probate and estate division, local Utah State Bar, it's a good group. They meet each month, typically at the Law and Justice Center. Again, you get to meet other attorneys in this practice area, good men and women. You'll find that in more complex cases, you can call. If I have complex charitable questions, I have a couple of guys I call in the Valley that are happy to assist. And they in turn can call me on different estate planning matters. So that, again, that camaraderie is very important. And then other local associations. Salt Lake Estate Planning Council. So if there were just 2 associations, again, in that estate planning area that you should absolutely belong to, I would say that the Salt Lake Estate Planning Council would probably be number 1. They have month after month after month, great presenters, great material. The Utah State Bars Association, Probate, Estate Planning Association, great second place. So if you can afford to belong to both, I think those are both great organizations. And then you'll find that, again, we see this all the time, right? As NBI rolls into town, there are great presentations on elder law, estate planning basics, advanced estate planning areas. That's another good way. And, curiously enough, there will come a time very soon when NBI reaches out to you and they ask you to present. And that's an excellent way, not a very, I always find it painful to get all that material put together for an NBI presentation. It's a big headache, but you sure learn a lot along the way. All right, let's move along. So, I know Christy asked me to provide a robust discussion about estate planning. I'm not sure that I'm going to teach you anything super valuable about putting together a will, putting together a trust, a power of attorney. I'll address some of that, but there are so many variables when it comes to drafting wills, drafting trusts. I fear that you're going to have to find kind of your path. Again, a lot of that will be dictated by the architecture, that software architecture you use. Is it a hot docs form that you have? Is it a BNA driven program? Is it an American Academy software program? Is it a Wealth Council program? The best thing you can do, though, is dive into 2 sources, really. The code, right, that covers probate, incapacity, death, transfers on death, payable on death, all those probate issues, Uniform Trust Act. I know you went through that in law school, but again, in a regular practice in this area, you should be very conversant with where all that information is located in the code, typically Chapter 75, right? Section 75. So let's talk about this idea, this notion of wills versus trusts. I mean, that really is at the core of most estate planning. So I am not a wills guy. I don't like wills. And I'll explain why. Most of my planning, 95% of my basic estate planning is designed around trusts. Now, sometimes I get this knock. Sometimes people have this notion that in order to justify the creation of a trust, you've got to have a lot of money. And granted, estate planning typically attracts people that have something to protect, right? It's not always the 10 million, the 5 million, the 1 million, but normally in an estate planning engagement, people are there because they want to protect something. So there's typically something at stake, right? A home, maybe a fair amount of equity in the home, a second home, a duplex, rental properties, cash accounts, and so forth. It's my opinion, maybe mine alone, that in this modern world, wills do not protect our wishes, estate planning wishes, very effectively. So let me describe this. As we know, a will, holographic, formal will, witnesses, acknowledgments, there are two basic components, right? A will identifies people who will manage the estate, personal representatives, executors, and so forth, right? The second thing is the distribution provision, right? This goes to so-and-so, this goes there. It can be very detailed or it can be very general. To all my children, to my surviving spouse. All right. Think about how most people own assets today. Where is most wealth transferred today? I would argue that a lot of wealth is transferred by virtue of a one-page document. What is it? A beneficiary designation, right? Think about how many assets are kicked along through time by way of beneficiary designations. Life insurance. Have you purchased life insurance before? What do you complete at the end of that application process for life insurance? I don't care if it's a $100,000 term or if it's a $100 million whole life. One page. Primary beneficiary, secondary beneficiary. Isn't it amazing that much wealth, the importance that lies behind that money or within that money is moved along at death through one page? So what about a will? What about a will that describes perhaps in great detail, this much life insurance goes here, and this goes here, and this goes here? How often do the provisions of that will and the beneficiary designation meet up? Is it 70% of the time? Is it 20% of the time? Well, which one controls? What controls? Does a provision within a will or a beneficiary contract at Northwestern, at New York Life control? Which one controls? The beneficiary designation. That contract controls. So you might have a recitation in a will that says, this life insurance will be divided up 15%, 20%, 5, 5, 5, 5, and 35. Yet, on the beneficiary form, you might have one designated beneficiary, 100%. What controls? The beneficiary designation. So let's move that out. That's true of life insurance. What else is passed along at death through a beneficiary contract? Annuities, right? Fixed, variable annuities. What about the big ones? IRAs, 401ks, 457s, 403bs, SEPs, simples. All of that money moves along through time by virtue of that beneficiary designation. So think of it this way. When we talk about a will or even a trust, that's only half the game. That's just half. The other part of good estate planning is being able to tell your clients, I'm going to set up a plan that will ensure your money will end up with the right people. Isn't that what they want to hear? You may only get part of that right if that beneficiary work isn't done, right? That's a huge, huge deal. If there's maybe, one of 3 takeaways, beneficiary planning and estate planning is critical. It's absolutely critical. So, I find that this happens all the time. I'll take a case I had just a few weeks ago. Husband and wife came in to see me. They had wills, what we call affectionately, I love you wills. Now what was interesting is they each had children from previous relationships. In estate planning, we will deal with that all day long. That's just modern society, isn't it? So the husband turns to me and says, Matt, it's my understanding that within this will, if I die, my sweetheart will be able to live in the house, enjoy the assets, but at her death, half of the estate will go back to my 2 kids from a previous relationship. And the wife voiced the same objective. I said, all right, well, let's see how that plays out. I get to be the devil in the room, right? So I asked, how do you own your home? And how do you suppose they owned it? Joint tenancy with rights of survivorship. Like, I don't know, 70% of married couples in America. What about cash accounts? How did they own their cash accounts? Joint. All right, so what about life insurance? Whom did they designate on life insurance? On his life insurance, who was the primary beneficiary? She was. And on hers, he was. Retirement plans? Everything. All right. So I told them, let's run this out. Thank goodness you're both alive, so you won't mind if I sort of take each of you out. I said, let's pick on the husband. Sir, let's say that you had passed away yesterday. Where does everything in your estate go? The moment you're gone, where does it go? To my wife, right? It's what you intended, right? Yeah, it is. All right. What happened to your will? Did we have to probate your will? Well, I don't know. No, because everything went to her by operation of law, right? Beneficiary contract, joint tenancy deed, right? The will, that will, the husband's will never see the light of day. Never. Never, ever, ever. So what happens to all the provisions in his will? They're gone. They're gone. All right, so we run this out through time. So now your wife owns everything. What if your kids are complete jerks? And the glue that bound, right, that relationship, it's gone. You're gone. Your kids don't call her. Their children who were sort of the grandkids, they don't come around as much. What might your sweetheart be inclined to do with all of the assets in her control? I mean, if there's no communication, 20 years go by, is she committed on any level, legal level, to honor the wishes in your will? And the answer is no. No. Does that happen? Happens all the time. Did she have some nefarious design about excluding or disinheriting his kids? No, absolutely not. Maybe the kindest person in this world, but life happens. The real problem is guys. And I'm talking to all the guys in the room. If their sweethearts die first, what happens to a lot of guys? They go down like cheap lawn chairs. Just, right? I had a client come in just the other day, His wife passed away 10 months ago. They had been married for 51 years. 2 kids. 51 years. 4 grandkids. Great marriage. So who did he bring with him to this appointment last week? Fiancé. Getting married when? November. What has he pledged to her? His $2 million home. They haven't even exchanged vows yet. And I am pleading with him, look, it might be what you will ultimately do, but maybe we should see how this relationship develops, right? Prenuptial agreement, things like that. So I'm not a will person. There are a lot of attorneys in this family that practice around wills. It's more of a, and it's not fair to say, but I would maybe characterize it more as kind of an old school, right? These are men and women that are in probate court every Wednesday morning. That's where they make their living, probate. Because wills, as we know, right, have to be probated. So going back to the story, the message I was trying to get to this couple was, your objectives that you thought were sealed up in that will may not come about. So in my view, good, or at least better estate planning, I think, is accomplished through a trust. Now, the whole notion of a trust is to create an entity that owns assets, like a corporation, like a limited liability company, right? It's sort of analogous there. But a trust is created to, this may sound too corny, but to seal up your wishes, whether as a single person, a married person, first marriage, third marriage, doesn't matter. Whatever you commit to that entity, you seal up and say, I've now transferred my house into this trust. It's no longer owned in joint tenancy, right? That home doesn't pass automatically to the survivor. Instead, my wife and I own our trust in our home in our trust. We know, or we have chosen, who the trustees will be throughout our lives. So if I'm the first to go, she's the trustee, right? She continues to serve where we had served together prior. Or I serve alone. And then when we're both gone, we know exactly who will serve at that point. My brother-in-law. So there's, in my opinion, there is more predictability about who will serve, and secondly, where the money will end up, right? Because what we've done now is the home, the brokerage account, the life insurance. When we go out to these institutions, the county recorder, the banks, credit unions, and we bring that asset out of our joint names, and we now subject it to the terms of the trust, right? We're sort of bound by those terms. Now, a lot of people have a little bit of anxiety. Well, man, if I have my home in my trust, does that mean that my children will now dictate whether I sell or not? No. No. If I need all that money within the trust that I've saved up, will it be there for healthcare expenses? Yeah. There's no commitment that you leave a maximum amount to your kids, right? Heirs, relatives, there's no commitment there. But again, there's more predictability, I believe, through that entity, that trust entity, than a will. All right, have I beaten that up enough? See my true colors? Okay. All right. Financial power of attorney. A couple things you should know. More and more institutions, credit unions, insurance companies, title companies, etc., when a power of attorney lands on an attorney's desk who works in that financial institution, there's typically a red flag that goes up. And what do you think that red flag is? Am I going to allow my institution to carry out the wishes of this agent? You know, the member of the bank we knew for 30 years, right? And we now understand that this member is incapacitated. The son or daughter has brought medical evidence. They've met the criteria set forth in that financial power of attorney. But I'll tell you what, institutions are nervous. Why? Because in this state alone, documented $50 million of financial fraud. Perpetrated by whom? I imagine sons and daughters, cousins, uncles, nephews, right? I mean, that financial power of attorney could be a very powerful document for good or for bad, right? All right, so banks and other financial institutions are requiring two things. Number one, specificity, right? The days of that financial power of attorney, I give my agent all rights to do all things. I won't bother to list everything, but I mean everything. Italicized, bold, done. That power of attorney will likely never be honored. Why? Because again, whether it's a $3 million IRA at Fidelity and the plan owner is incompetent and can't take out her or his required minimum distribution at age 74, or if it's a $1,000 bank account at Zions Bank. Again, the bank wants to know that the agent has specific rights, specific powers. So your power of attorney should be specific as to banking powers, life insurance transactions, retirement transactions. Remember, you've got to think like that bank or that financial institution. If you are asking to withdraw cash out of a life insurance policy and you're legal counsel for the life insurance company, what would you want? What would you want in that power of attorney that would make you feel better to release information back to that agent? Specificity, okay? The second thing, time relevance. Now this, I get a ton of feedback on this issue. I have people say in meetings like this, well, Matt, that's all fine and well, but I still have a power of attorney my mom signed in 1971, and I'm still using that today. Well, okay, that's sometimes the case. I am finding, though, with more and more financial institutions, their unwillingness to accept powers of attorney dating too far back. So here's an example. New York Life, huge insurance company in the US, right? I had a client that I did estate planning for 3 years ago. 12 to 14 months after she put together the plan, her mental health began to deteriorate, and it continued. Until one day her son called and said, Matt, it's pretty much official. Mom is, we believe, completely incapacitated. I said, well, thank goodness we got the planning done. He said, yeah, Matt, I couldn't agree more. But Mom has an insurance policy at New York Life. The cost of her care is doing this, right? It's that meteoric rise, $7,000, $8,000 a month. Matt, we may need to tap the cash value in that life insurance policy. Can you send the power of attorney back to New York Life so we can ask questions about how much? I said, yeah, done. Sent it off. New York Life responds and says, Hey, fantastic document, very specific, enumerates all the rights and authorities on this life insurance issue. But there's one problem. The power of attorney was dated 3 years ago. We are a 2-year company. I said, 2 years? I mean, are you serious? Yeah. Yeah, in order for us to comply with your request, that power of attorney must be signed within 2 years, the last 2 years. So it's too late. I mean, my client cannot sign another thing in her life, at least not competently, right? Well, I'm sorry, then I guess what you'll need is what? A conservatorship, right? You got to go to court, petition the court with medical evidence, and have a conservator appointed. A couple $1,000. Clients would not like that at all. So I fought with legal. Legal ultimately accepted that POA. Thank goodness. But it was a tough lesson, a scary lesson, that at least for that company, they want a very time-relevant document. So you'll find in your practice that those powers of attorney might be perfectly acceptable, or they might get too old and stale, which brings me to the next point, right? Review. I'm not sure this is true in any other legal domain. It might be true of a relationship you have with a business owner, sort of that long-term business relationship. You help them form the entity. You help them grow their business. You advise them on everything from human resources to mergers and acquisitions. But estate planning is fairly unique in that you have that initial engagement, and then what? Those documents sort of exist. They go through time. And if they're not reviewed on a pretty continuous basis, what begins to happen? They rust out. I mean, they really do. They rust out. And all of a sudden, this issue of liability might surface. Hey, Matt, that power of attorney you put together in 2003, when were you going to tell us about this institutional sensitivity to old documents, right? Were you going to tell us about that? We can't use it now. Mom is incompetent. There's a lot of money that needs to be in motion, and we can't put the money in motion. So, all right. Healthcare directives. As of 2008, Utah, like many other states, has its own medical directive. And it's really composed of two things. Number one, the nomination of healthcare decision makers, right? Healthcare agents. Those agents step in when the signor is incapable of making healthcare decisions for him or herself. Decisions about medications, place of care, second opinions, whatever the case may be. The other part of that healthcare directive is the living will. A strange name, I know, living will, but it's the end of life. Not to be confused with a DNR. Right? A lot of people think when they sign that medical directive, they think they're signing a do not resuscitate order, and they're not. That's a completely different document, which we call in the state of Utah a POLST, P-O-L-S-T, Physician Order Life-Sustaining Treatment Plan, something like that, POLST. That document is for individuals who are at the very end, last stage of cancer. Typically when my clients get there, the oncologist is typically mapping out with that patient what care and what care not to give over the last 30, 60 days of that patient's life. When to arrest artificial support, all those things. So the living will is really that directive we give our agents when all medical care has been exhausted and the treatment we're receiving is now in the words that that directive uses, prolonging our life, right? And there are 4 options that you'll review with clients on a regular basis, Now that directive, that healthcare directive, is no cost. So whenever you have a client that goes into a hospital, even for a simple outpatient, inpatient, in-hospital surgery, the question they always pose is what? Do you have a living will? Yes or no? So hospitals can provide that. Our job, I suppose, is to be a skilled professional that can guide them through that directive. The most difficult document any of my clients sign on any given day is what? It's not always the trust. It can be that crazy medical directive. Because I have clients that really labor through that end of life, those end of life options. You know, do I want this, or do I put this heavy burden on my daughter or my son? Is that fair, or is it unfair? So be sensitive to how important and how sometimes difficult it is for a client to navigate that directive. The third thing that we add at this firm to that medical directive is a HIPAA authorization. HIPAA, Health Information Portability and Accountability Act. The name itself doesn't really describe what that is, but as you may know, that's the privacy law that protects our healthcare information. Well, from whom? Right? It was probably intended to keep our employers away from sensitive information so that they don't make hiring decisions about Matt's life expectancy or lack thereof, right? Insurance companies to adjust rates based on, you know, again, my father's heart attack at 58. Anyway, so even between spouses, patients and children, patients and relatives, how freely does that information, the patient's information, flow between other parties? It's not supposed to flow at all unless the patient has done what? Voluntarily consented to the disclosure of that, or if the patient is unable to consent, the patient has already, in your directive, identified people they trust to be what? HIPAA authorized representatives. Right, so those 3 parts. Any questions on that medical directive? And again, you can Google that. Utah Medical Directive, probably in PDF form. There are likely instructions that will give you a really good idea about how that works. One of the things that Christy and I have done is, you know, I've invited her into a number of signings just so that she can sit through and at least hear my version of that medical directive, how to explain it, how to present it, how to push clients past that, what they feel sometimes is an impossible question to answer. I mean, you will have clients that will get stuck. And unless you help them, you know, get past that, they may never execute that document. All right. Where is the money going? Now, I've talked about this, haven't I? I talked about it in that will format. So as I talked about that married couple, the wills did not seem to help all the modern ways we pass assets along. Joint tenancy, joint bank accounts, adding children as other joint tenants after the first spouse dies, right? But at the core of this, if you are going to practice in this area, it is critical that you understand the financial products your client owns, right? It's critical. It's It's not even a good thing to have a surface understanding. You really need to know what a variable annuity is. You need to understand what a fixed annuity within an IRA shell is all about. You need to understand that. It's helpful to understand all those life insurance products. And it's a crazy, crazy world. In that life insurance domain, you have your traditional life insurance products, right? Term, whole life, universal life, second to die, life insurance with cash value, life insurance without cash value, riders within life insurance, group-owned life insurance, company-owned life insurance, buy-sell life insurance. Then you have that other world of investment products, right? Brokerage accounts, margined accounts, all of those things. And then you really should have a very, very good understanding about real estate law, especially deeds, transfers, life estates, the difference between joint tenancy, tenancy in common, when those are severed or fractured. So as you're advising clients, again, you have to be able to tell them with a high degree of certainty, Mr. and Mrs. Jones, I can tell you right now in this legal architecture where this property will go through time. I can honestly, with confidence, tell you how this will pass along. I can tell you that this will be a problem if you keep it in this current legal format, right? So a good understanding about deed transfers and insurance and financial products. And then, as I talked about ad nauseum, right? Beneficiary designations. So let me bring up one other issue. In fact, a couple of issues. On the beneficiary designation side, you may find in your practice a considerable amount of debate about designating a trust as the beneficiary of certain financial products. IRAs, 401ks. I had a debate with a CPA last year who thought I was going to jail. I mean, he honestly did. I had a client that was diagnosed with terminal cancer. And the client had basically two simple requests. Matt, I know I'm going to be gone within 12 months. He was actually here for 24 months. But the issue was this. He wanted a fairly significant IRA balance to be divided as follows. 50% to his wife for all of her needs, and the other 50% to his 5 kids in equal parts. But he did not want the children to be able to go in and draw out of their IRA share all of it in one taxable year. He had spent 40 years working, sacrificing, watching the stock market. He wanted his children to be able to take out what we call the required minimum distribution each year. In other words, he wanted that share to be more of an annuity that would last through time, that would throw off the $5,000 a year, not be swallowed up in one $75,000, $150,000 withdrawal. So we used a trust as the conduit through which the children's money came in, because it was within the trust that we mapped out what I just described. So the CPA took a look at that and said, that's illegal. You might go to jail. Now, of course, he gave that information to the client first, which I love. In a professional community, I'd really like for that type of stuff to get to the client first. So, who do I get a call from? Yeah, the widow who is freaking out, to put it mildly. I mean, she was coming undone because she had known the CPA a lot longer than she had known me. So I said, look, Margaret, I don't know that there's anything I can tell you right now that will help. Number one, what we did wasn't illegal. Number two, I fear that, and this is kind of hard for me to say, that your accountant doesn't really understand this, but I'll commit to help him understand it. And I'll have to get back to you, but please don't worry about this. Well, what's interesting is the financial advisor she had, I was able to work with their legal department, who blessed the plan, called her and told her, this is good, solid progressive planning. You're going to be okay. Your CPA is not right. Now, again, what you'll try to find though in that professional community is synergies around that information, which means that you might have to go out. You're going to have to go out and find relationships where you have common philosophies, common knowledge, right? Because when you have that commonality, those advisors will send you a lot more business. Promise, a lot more business. All right, I need to wrap things up, don't I, Christy? So I'm going to run through this in like 2 minutes. Is that all right? Flat fee versus hourly. I am, when possible, flat fee, all the time. The client I just met with, I said, I will do your basic estate planning and an LLC for X amount. I typically ask for half as a retainer and the remaining balance when I sign the documents. I rarely, if ever, get into a situation where I have AR. And that is, if you're in any firm, right? There is nothing worse than old AR, accounts receivable. You know, money that just hangs out there. And as that relationship goes through time with that client, what happens when it comes to unpaid balances? It's never good. Never. Ever, ever. All right. Managing client expectations. In my practice, I rarely, and sometimes I break this rule, I shouldn't, but I rarely send out drafts. Why? Well, my experience tells me if you send out a draft of a trust, a power of attorney, how quickly will that client get back to you? I mean, the process of estate planning could go on for 6 months, a year. If the clients delay long enough, what happens to the relationship? It deteriorates. Who's at fault? Unfortunately, sometimes the blame comes back where? Back here. Hey, Matt, you really should have been the one that followed up every week to get me to send those documents in that I was reluctant to send in. What? That doesn't make any sense. So my advice, don't send out drafts. Instead, make sure that you allocate enough time at the signing meeting to cover all of the ground you need to. To have staff there to make edits, if you missed a spelling on a name, if they've reconsidered a distribution provision. In my opinion, it's never productive to send out drafts. Reviews, have an upfront contract with your clients about what you will charge for and what you won't charge for. In the estate planning community, and I'll be honest, I have colleagues who charge for every single phone call, fax, review. You know, $265 an hour, $310 an hour. I made the decision, it may not be right for you, to never charge for a phone call. I don't do it. And I'll tell you, the karma that creates with the client is sky high. So if my practice is based more on word of mouth referrals, that's the right play for me, but it may not be for you. Third-party practice services, I've talked about those, haven't I? And then, last but not least, play to your strengths, right? Remember that technician or someone who is behind the scenes? Find people that complement your weaknesses and strengths in your firm. Don't get spread too thin. You can literally go to lunch, breakfast with an endless number of people in this valley. Life insurance professionals, brokers, title insurance people, other attorneys. But you know what you'll find? In due time, you will have probably fewer than 10 people who make up all the referral business you get. I promise you. Concentrate on those sources. Go to lunch routinely. Go to events together where you're learning together. One year, this is silly, I know, and this is probably on camera. I dressed up as Santa one year, and I took baskets to key advisors. You know, it was corny, I know. But to this day, what do those advisors talk about? Hey Matt, remember that day you were Santa and you came out to the house with that fruit basket? Oh yeah, I do remember that. That was weird, wasn't it? No, that was great. Find ways to strengthen in your own way those relationships. Quid pro quo, be careful. A lot of advisors will say, I'll send you a case if you'll send me a case. Sometimes it just never works. Sometimes what you'll need to do up front with that relationship is say, I promise to always do competent work for your clients. I don't know how often, frequently, I will get cases back to you. It might be that the 4 cases you send me, I send 1 back to you. But you will quickly disappoint in that relationship if you don't have that discussion up front. Websites and social media. I'm not a real big proponent professionally of Facebook, Twitter, thank you. See, I'm not that old either, Christy, right?
No, yeah.
No, not at all. I mean, LinkedIn, I participate there, but I've never had one client come through LinkedIn. All my clients come through my existing client pool and advisors. That's it. I've never had social media kick up. But your website. People are on the web, as you know. We are on the web every day. People, I promise you, will find you through the web. So if you want a web presence, make it a robust website, right? You've got to keep that thing active. All those keywords, and you might spend the money to keep that thing relevant so it's in that first page. If you're not on that first page, you might as well be dead on the web. People won't find you. Specialty areas, play to your strengths, right? If you want to do disability law, do it. Don't try to practice in other areas. If you want to do high net worth law, be there. But you probably have to take calculated steps through everything else to get to that specialty area.